Okay, let's dive right into this explainer. We really need to confront that wild, chaotic version of courtroom cross-examinations we're always seeing in movies and on TV. You know exactly the scenes I'm talking about, right? The lawyer is pacing the floor, shouting aggressively at the witness, and suddenly, under all that intense pressure, the witness just breaks down in tears and confesses to the whole thing right there on the stand. It makes for absolutely incredible entertainment. But, as we'll see, the reality of the legal system is actually quite different.
So it begs the question, is cross-examination just this dramatic show put on for the courtroom? Well, throughout this explainer, we're going to explore how real cross-examination isn't about those cinematic gotcha moments at all. Actually, it's a highly structured, meticulously rule-bound test of human memory and perception.
Here's our roadmap for today. We'll be covering 1. The quest for truth. 2. The human memory problem. 3. The rule of fair play. 4. The art of contradiction. And finally, 5. Omissions as evidence. Let's get into it.
Section 1. The quest for truth, detecting falsehood, not harassment.
Now, before we even think about how to trap a liar, we have to understand the true fundamental objective here. It's really not about winning a shouting match or just trying to make someone look foolish for the fun of it. Take a look at this really powerful quote from the Govind versus State of MP case. The Madhya Pradesh High Court explicitly points out that cross-examination is, quote, the most efficacious test to discover the truth. They describe it as this massive intellectual effort designed to expose bias and detect falsehoods. But, and this is a big but, look closely at the end of that quote. The court emphasizes that it must absolutely never be used as a means of harassment or to just humiliate a witness. It's a rigorous pursuit of the truth, not a free pass for personal attacks.
Moving on to Section 2, the human memory problem, witnesses aren't video cameras.
In cases like Balu Saddam Khalde, the Supreme Court openly acknowledges that discrepancies in testimony, they happen entirely naturally. And why is that? Because witnesses just aren't human tape recorders. They don't have perfect photographic memories. Their minds aren't replaying a literal videotape of the event. Think about it. People are often completely overtaken by sudden surprise events, which means their mental faculties aren't exactly primed to absorb every tiny microscopic detail. On top of that, a person's sense of time can vary wildly, and honestly, that piercing, highly formal courtroom atmosphere, it can totally overawe and confuse even a 100% truthful person. Usually, people are only going to recall the general vibe or purport of a conversation, definitely not the exact words. So the law actually has to do the heavy lifting of distinguishing between just natural memory decay and actual intentional deception.
Which brings us to Section 3, the rule of fair play. No courtroom ambushes.
Because human memory is inherently so fragile and flawed, the law demands absolute fairness when a lawyer is trying to prove a witness is lying on the stand. Lord Halsbury, whose words were heavily relied upon in the Karapiat case, literally calls it a perfect outrage to ambush a witness. Basically, a lawyer can't just sit back, listen to a witness testify, decline to ask them any questions whatsoever, and then later turn around and argue to the judge that the witness is a liar. No way. If you intend to impeach their credit, fair play dictates you've got to confront them right there while they are still in the witness box. You literally have to give them a fair fighting chance to explain themselves.
All right, Section 4, the art of contradiction, trapping a witness in a lie.
So now that we understand the ground rules, let's look at how literal the courts are when defining this so-called trap. If you look at the Oxford Dictionary, to contradict simply means to affirm to the contrary or to declare untrue. And the Supreme Court, in the landmark Tahsildar Singh case, relied on this exact literal definition. They explained that a contradiction happens when a statement made in court is completely, 100% irreconcilable with a previous statement made by that very same person.
And here is how this trap is actually legally set. Under Section 145 of the Indian Evidence Act, lawyers have to follow this incredibly meticulous three-step procedure. First, they use previous statements that are in writing. Second, and this is where the real strategy comes into play, they actually don't need to show or prove that writing to the witness beforehand. That's how they avoid showing their hand too early. But third, if they want to actually use it to formally contradict the witness, they must draw the witness's attention to those specific parts before proving the writing. It's like this highly strategic procedural dance.
To give you a clear picture, this is what the court in the Tahsildar Singh ruling calls a patent contradiction. On one side, you have a witness saying, I saw A hit B. But then on the other side, they previously claimed, I did not see A hit B. It's black and white. These two statements simply cannot coexist. If a lawyer can highlight this type of irreconcilable difference between, say, a police statement and court testimony, they effectively shatter the witness's credibility on that specific point.
But what's super fascinating here, coming from the N. Sri Rama Reddy case, is that these previous statements aren't just limited to dusty old paper files anymore. The law actually embraces new tech. Tape-recorded conversations are totally admissible as previous statements to contradict a witness. Now, of course, that's provided the recording's accuracy is definitively proven and the voices are identified. But it just goes to show how the system's search for truth adapts to the tools we use in the modern era.
Let's head into our final part, Section 5, Omissions as Evidence. What you didn't say matters.
Now, this covers those tricky scenarios where a witness doesn't just blatantly change their story, but instead they leave out absolutely crucial details. Imagine this. A witness is confidently testifying in court, saying, "When I arrived, X was running away, chased by A and B." But when you look at their much earlier statement to the investigating police officer, they completely omitted any mention whatsoever of A and B chasing X. Under Section 162 of the Code of Criminal Procedure, if a witness omits a highly material point to the police that they later miraculously seem to remember in court, that glaring omission legally functions as a vital contradiction.
As the Tahsildar Singh case clearly dictates, the meaning of the word contradiction absolutely must include an omission in a previous statement, which, by implication, amounts to a contradiction. So the ultimate takeaway for us here is that a truly skilled lawyer doesn't just listen to the words that are spoken out loud. They can and will cross-examine and confront a witness on what they completely failed to say, thoroughly testing their overall veracity.
So it leaves us with this final thought. If human memory is inherently so flawed and so fragile, is this highly rigid, technical trap of cross-examination our only true safeguard for justice? I really want you to take this thought away from our explainer today. While real courtroom cross-examination might lack the screaming, flashy drama of TV shows, these meticulous rules of evidence, the rules of contradiction, omission, and fair play, they are what ensure that the ultimate search for truth never becomes an outrage of fairness. The justice system is expertly designed to protect the honest while carefully and legally trapping the deceptive.